Good morning, and thank you for the opportunity to speak with you today. My name is Lee Wenling, and I'm a land law specialist with focus on the legal framework that governs land ownership and registration in English and Wales. I've been invited to talk about how our current system of land ownership and registration is working and whether it meets the need of today's society. The Land Registration Act 2002 was meant to make land ownership clearer and more efficient and easier to understand, but some problems remains. Around 10% of the land is on registration, and some rights over the land still exist without being shown in the register. In this talk, I'll explain one of the core ideas behind the system, the mirror principle, how it works in practice, and what changes it might help to improve the land system for everyone. Mirror principle is a foundational concept in the land registration system of English and Wales, reflecting the idea that the land registry should present a complete and accurate picture of the legal title to a piece of land. Maintained by the HN Land Registry, the register is composed of the three sections: the Proprietary Register, Property Register, and Charters Register, each containing crucial detail about the ownership boundaries and any other charged circumstances under the land. Under this principle, a person inspecting the register should rely on solely of what show is without needing to investigate earlier dates or unregistered document. This is reinforced by the Section 55 of the Land Registration 2002, which provides that a registered property is deemed to have absolute title, even when their registration may have resulted from the mistake. The mirror principle intended to streamline conveyancing by eliminating the needs of the repetitive investigation for past titles which characterize unregistered land transactions. After affirmed by Lord Oliver in AB National Building Society versus Kent, the registrar should be define the source of asserting title. The LRA 2002 enhanced the principle of reliability by reducing the number of rights that existed of the registration and recruiting more interests to be recorded in order to bind three parties. However, the principle is not perfect. A significant flaw often referred to a crack in the mirror lies to continue in existence of overriding interests, right which bind purchaser despite not appearing on the registration. This includes certain short leases and interests of the person in actual occupation, which are legally recognized but invincible on the inspecting of registration. While registers offer a high level of transparency, these are the conception exceptions mean it does not always provide a complete picture challenging the absolute reliability that the mirror principle aspires to deliver. The Curtin principle is one of the three central principles underpinning the registered land system in English and Wales, operating alongside of the mirror and insurance principle. It ensures that equable interest, particularly benefits interests under a trust, are kept off the face of registration. Rather than appealing on the register, these interests are hidden behind a legal curtain and are dealt through the process of overreaching. Under Section 2 and Section 27 of the Law Property Act 1925, if a purchaser pays the purchase money to two or more trustees, the beneficial interest is overreached, meaning it is detached and the land is transferred to the purchaser money. This merchandise allows all purchasers to take the land free of those equitable rights, even if the beneficiaries are in actual occupations. This was confirmed in City of London Building Society versus Fletch, where the beneficial interests of the occupiers were overreached through payments to two trustees. Similarly, in the Bank of State of Bank versus India Scoot, overreaching a court even when no new money was advanced, as the transaction satisfied pre-existing debts. Although these interests do not appear in the registration, beneficiary may still enter a restriction to alert buyers that the need of proper overreaching. Overall, the Curtin principle provides practical security for purchaser, while ensuring that trust arrangement does not interfere with the clarity or usable of the register. Insurance principle is a core element of the land registration system in English and Wales, designed to uphold the integrity of the register by providing state-backed compensation whenever it occurs. Under Schedule 8 of Land Registration Act 2002, individuals who suffer loss due to a mistake or ratification of the register may be entitled to indemnity for the public funds, reinforcing public trust in the system even when it fails to present a complete or accurate picture. Section 58 confirms that the register is conclusive evidence of the title, but this assurance that it's not absolute. The law recognizes that certain proprietary rights can still exist off the register, known as overriding interests, which bind purchaser regardless of whether they have appeared in the register. This includes, for example, legal lease not exceeding 7 years and right held by the person in actual occupation as set out as Schedule 1 and 3 of the LRA 2002. While the Act is no longer used to exploit terminology of overriding interest from the earlier 1925 legislation, it continues to recognize their overriding status. These unregistered rights are over-discoverable through physical inspection of the land, was in truth what has been described as the crack in the mirror, undermining that the idea of the register fully reflects all relevant rights. Thus, the insurance principle offers financial protection. It also highlights the system reliance of balancing practical safeguards with the theoretical clarity of the mirror principle. Collectively, these principles are intended to make the land both defining and accessible, such as it reduces the transaction costs, increases the market efficiency, and prevents the unnecessary dispute. However, now I will explore that the mirror principle particularly have heavily compromised in the practice due to various factors, notability, the existence of the overriding interest, and the incomplete of the registration. Although the mirror principle aspires to certainty, its application is not absolute, and its effectiveness is significantly weakened by the continued existence of the overriding interest. There is interest that are binds even though they are not recorded on the registration. The Land Registration Act 2002 attempted to narrow the scope of such interests compared to the LRA 1925, particularly by replacing the wide-ranging Section 70 Clause 1 with Schedule 1 and Schedule 3 of the 2002 Act. Nonetheless, overriding interest continues to cause legal uncertainty, especially to those who base on actual occupations under Paragraph 2, Section Schedule 3. The leading case here is William and Glyn's Bank versus Boland, where the House of Lords ruled that a wife who made a financial contribution to the purchase of the family home and was in actual occupation held an equitable interest that overrode her husband's registered title and the bank's mortgage. This principle has caused particularly anxiety in conveyancing, and it requires the practitioner to investigate actual occupation on the ground, undermining the idea that the registration alone is definitive. This approach reaffirmed in Lloyds Bank versus Rosset, where the Lloyds Bridge recognized that even minimal contribution to property equities, if accompanied by express or inference common intention, could give a rise to constructive trust, further complementing the mirror. Additionally, the case has tried to clarify the scope of actual occupation. In Choker v. Choker, the court held that temporary absence does not negate the occupation. The wife's brief hospital stays while giving birth did not cause her to lose her overriding interest. By contrast, in Stockholm Finance Limitation v. Garden Holding, a Saudi princess who has not visited her London home in over a year and whose presence was limited to a cleaner and belongings was not liable to be in actual occupation. In this decision, in AB National Building Society versus Kent, further limitation that the doctrine by asserting that the right must has before or at the moment complete and not merely in registration. These cases highlight the lack of clarity and predictability over the surrounding overriding interests, which stands in direct opposition to the mirror principle. Purchasers are left vulnerable and undiscoverable rights unless they physically inspect the property, a throwback to the pre-recognition of the practice. These overriding rights effectively pierce the mirror, contradicting the goal of the transparency and encompass costly due to diligent requirements on the buyer. The issue is further complemented by the grading of the registration title. Not all registered title carries the same legal weight. For example, possessory title grants under the Section 9 Clause 5 LRA 2002 when a full title deeds are missing does not guarantee that the applicant has a full ownership. It remains vulnerable and adverse claims and offer less security and biased mortgages. Through the possessory title may be upgraded to absolute after 12 years under the Section 62 LRA 2002, this delay creates a long-term uncertainty. A notable example is Baxter versus Mannion, where the Court of Appeal reversed that the registration of the title obtained via adverse possession after discovering the factual possession was not proven. In this case, the court emphasized that the register should not override legal reality when it is fundamentally flawed. Similarity qualified title, through rare, is issued when their doubt about a legal right's validity is also weaken the reliability of the register. Good leasehold title, another category, may be granted to the freehold ownership is unknown and unregistered, again leading to legal gray areas. This category serves as evidence that the register is not a perfect mirror, but rather the best efforts reflection subject to exceptions and degrees of certainty. Furthermore, approximately of 10% of land remains unregistered, particularly in rural areas or institute estates where the land remains unregistered, continues to depend on the title production of the paper deeds ability to prove that a 15 years chain of title, which is both ineffective and vulnerable to loss, frauds, and ambiguity. These lands are not visible to the public inspections. They are not backed to the insurance principle, and also the certainty are not subject to the protection intended by the LRA 2002. This gap coverage represents a fundamental failure, accessibility, and transparency. In light of these issues, I propose several target reforms to strengthen the operation of the mirror principle to reduce uncertainty and align the land registration system with the public interest in a modern digital society. First, there must be a final universal deadline for the registration of all remaining unregistered land. The piecemeal approach that current use, whereby the first registration is triggered and only upon sales, mortgage, or leases exceeding 7 years, is no longer sufficient. As we enter a world of AI-assisted conveyancing and public digital records, it is untenable to allow the 10% land to remain hidden from scrutiny. An active program of compulsory registration potential support by financing, incentive, or simplify applications processes for the possessory titles should be implemented. Secondly, I urge to statutory reform to narrow down the category of overriding interest. While it may not be practical to abolish that altogether, particularly in the context of vulnerable manufacturing under trust, their scopes should be better defined. For example, it would be desirable if to require the registration of beneficial interests were known to tie the validity of actual occupation's right to a require or visible to continuous physical presence. These changes address that inconsistency as in case of law from the Bolam to Stockholm Financial and reduce the volume of litigation based on the factual occupation. Third, the government should consider that automated upgrading merchandise for inferior title. For instance, possessive of goods or leasehold titles should be automatically renewed by the HM law registration after a fixed period such as 10 or 12 years. With the burden of the objecting feeling of this assertive and adverse claim, this would reduce the administration of the bottlenecks and encourages proactivity title clarifications. Furthermore, there must be increase of education and public engagement regarding what the register does and does not, revealing many members of the public still believe that the register reflects that full ownership in all cases, unaware of overriding interest restriction or the limitations of a possessive title. A national public awareness campaign supported by a clear guidance for conveyancing and estate agents would promote information or informed transactions to reduce post-sales disputes. Finally, we should harness the power of technology and artificial intelligence to enhance the detection of risks. AI could scan that registrable events such as repeated possession claims or occupancy patterns inconsistent with former titles to flag potential overriding interests or conflicts. As conveyancing moves online, the registration should integrate such as functionable to bring ideas of the mirror principle closer to reality. To conclude, the vision land of the Land Registration Act 2002 that is a modern accessibility and certain register remain compelling, but in this current state, the system falls short. The mirror principle true foundation is compromised by the unregistered land, overriding interest, and the legal complexity of varying title types. Purchaser cannot rely solely on the registered, and the possession of exceptional continues to be demand causation, investigation, and some cases litigation. Nevertheless, the reform is both necessary and achievable. By addressing the status of overriding interests, closing on the gaps on unregistered land, automatically title upgrades, and investing legal literacy and digital innovation, we can realize that the potential of the 2000 Act The aim is must be created a land registration framework that is not only efficiency for lawyers and also clear enough for the purchaser, and fair transparency just to that its treatment to all land users, from like host owners to tenants and from developers to the general public. Thank you for your attention.